Hello, everybody. It is June 4th, 2020. I am Alisa Hopkins, and I am going to be your guest host today. Steve Holden was called out last minute with a corporate client of ours. As you know, COVID can be very unpredictable, and we're on the go all the time to help our clients. So today I am going to be presenting for you a special edition we have on workers' compensation, how it relates to COVID-19. So before we get started, before I introduce our guests, I want to just kind of talk about a little bit of what has happened the last week as it relates to COVID-19. Obviously, we have had some substantial things happening around the country and in the news, and it does have an impact. A lot of people have been asking us, a lot of our clients, you know, what does this mean for my business? What does this mean for the spread of COVID-19? So I just kind of want to share a little bit about what's happened the past week. There might be some facts and news that you haven't heard about. So let me kind of start here. Oops. On my slide here. There we go. So this week, what have we learned? Obviously, the biggest thing in the news right now is the riots and the protests taking place across the country. We have them here. I think that pretty much everyone has seen something to this effect happening in their city. Does it mean that COVID-19 is gone or social distancing is no longer necessary? That's not the case. That's not the case at all. In fact, we've already been discussing and hearing from experts about how these riots and protests can be impacted by COVID-19 and the infection rate. So kind of what we have learned is that experts are saying that they believe that the use of the tear gas and the pepper spray that has been occurring during these riots by police officers, it does obviously invoke coughing, and we obviously have close quarters, a lot of people smashed together. There may be a spike in COVID-19 cases due to this fact. These irritants that are used can in fact damage the lungs and can make a person more susceptible to COVID-19 and contraction. So what this would mean is we may very well see another wave of COVID-19 cases occur. This week, they've also announced that experts believe that COVID-19 symptoms are inducing some level of brain trauma. This could be impact in the loss of the sense of smell and taste, and also silent hypoxia. On a little bit, nicer note, we could say that, Dr. Fauci has said that he does believe we are making substantial steps to possibly having a vaccine developed by the end of the year. And while he's cautiously optimistic, he does believe that it is in the realm of reality for us right now. So that is something that we should really hold on to at this point in time. There's a lot of potentially negative news regarding COVID-19 in the news, but there is a glimmer of positivity that we can report, which is very nice. Some more statistics that have come out. We hear about, when we discuss social distancing, everyone knows stay 6 feet apart. Some statistics have come out that indicates that a distance of social distancing within 3 feet, there is about a 3% infection rate chance if you're three feet apart. Whenever you start closing that gap at 3 feet, it does jump significantly to 13% chance of infection rate. So those are just some of the facts and updates that we have for you this week. Right now, I'd like to introduce our panel to you. Our first panelist is James Daniel. Hey there, James. Hello.
Good morning, Alisa. Thank you for having me.
Thank you for being here. James is the head of Holden Litigation's Workers' Compensation Practice Group. He's been in practice over 20 years and specializes in workers' compensation law. So we're very glad to have him here with us. Our next panelist is the Honorable Judge Tara Inhofe.
Good morning.
Good morning, Judge. Judge Inhofe is the Administrative Law Judge for the Oklahoma Workers' Compensation Commission, and we're very honored to have you here today. Thank you for being here.
Thanks for having me.
Thank you. And then our final panelist is Miss Esther Sanders. How are you doing this morning?
Good, thank you.
Thank you. Ms. Sanders is president of Sanders and Associates, and she focuses her practice on claimants' workplace injuries. So we have a vast and very knowledgeable group here today, and we're going to talk about all aspects of workers' compensation and COVID-19. So with that being said, I will turn it over to James to get us started.
Thank you, Alisa. Thank you very much. There are a lot of changes occurring due to COVID-19, as we all know. One of which is directly related to COVID-19. Those changes are workers' compensation. Specifically, what's being discussed is causation, evidentiary issues, presumption of whether or not the occupational disease was contracted at work. These are going to be hard questions to deal with in the future. I do anticipate that a jurist like Judge Inhofe can handle those kind of things, and I definitely know that Ms. Sanders can handle it, having appeared against her numerous times over the years, locking horns on issues. She is a strident advocate for her position. And I'm glad to have y'all both here. I'd like to start out by asking you both, how has COVID-19 specifically, how has that changed the practice of how you do business, at least in the state of Oklahoma? And I'd like to ask Judge Inhofe to start us all off. Thank you.
Good morning. Well, before March 15, we were business as usual. We have an office of our agency in Oklahoma City, and we also have one in Tulsa. 4 judges sitting in Oklahoma City, 2 here in Tulsa where I am. Before COVID-19 hit, we were doing a full slate of pre-hearing conferences and trial dockets every day, Monday to Thursday. People coming in, attorneys coming in, appearing in person for both pre-hearing conferences and trials. We had a full waiting room full of injured persons and their families or friends. It was a very, very bustling place. Now we have slowly over the last couple of months gone from actually being closed for a 2-week period of time to slowly getting our processes back up and running. The first thing that started was electronic filing where available, and then actually filing by U.S. mail. Also, the judges started to approve settlements online by review of documents. That's in both unrepresented settlements and represented settlements. The attorneys send us the documents, we review them, send them on for processing if appropriate. Our signature is affixed, and people get the documents back electronically. It's been a really just a fantastic way of continuing to get benefits and monies to injured workers where needed. In the last couple of weeks, we've added pre-hearing conference dockets every week, 1 time for each judge. They're very heavy pre-hearing conference dockets because, as you can imagine, we do have a backlog of things that are needing to be heard. Our pre-hearing conference dockets, though, are all electronic. Still nobody coming into the actual office. Everybody is emailing announcements, and we're having discussions telephonically as needed. And actually the judges have all been available telephonically the entire time if need be. This week we started trials, which we are doing in person. However, they're staged. 9 a.m., 11 a.m., 1 p.m., 3 p.m. to protect people, both employees of the commission and then those persons who would come into the commission for those trials to minimize contacts, essentially.
And y'all are doing a good job with that, and we appreciate that as well. Esther, how have you been conducting your business, or how has it changed over the last few months? Because I know that you do a very active workers' compensation claimant business.
Boy, it's been a lot of change. Things that we never imagined before, or that we would even be able to, you know, physically, I guess, do it, but now we are, and a lot of it seems to be working really well. But for instance, to take you back to when this all first kind of broke, you know, we of course were concerned about our employees as well as our clients, and not knowing exactly, you know, what was going to happen. So most everyone in my office started working remotely, something we had never done before. And so that was, you know, interesting just to get that set up. We still have some people working remotely currently, because they are high-risk individuals, being in the older age category. When I say older, I don't mean old, I just mean older, like 60s and on up. Also, they perhaps have, you know, higher health risks, like autoimmune deficiencies or COPD or things like that. So even though our office is still currently closed as far as people coming and going, we are back in the office. Myself and one other person did continue to work from the office because we have our own building where other people wouldn't be coming and going, but we needed to be able to process the mail for the clients who get their weekly paychecks here. The injured workers, you know, they'll receive weekly benefits. So those had to be processed and got to the client. You know, we were able, as Judge Inhofe indicated, we're able to go ahead and process settlements, which was such a relief for a lot of people who were really counting on that to be able to just pay their everyday bills. And then, you know, maybe someone else in their household now no longer had an income because of something with COVID-19. So people were really dependent on any help that they could get through the court. And so we've been thankful for what they have been able to do. But, you know, we started doing Zoom right away. We did Zoom mediations. We've done some Zoom depositions. In fact, I think it was last week, had a Zoom hearing with Judge Inhofe with several lawyers that was involved on the other side of a case. And it was, I mean, it was as effective as being in the courtroom, I feel. So, things have changed, but progress is still being made.
I agree. I'm glad that progress is being made, because, you know, when we don't have, as lawyers, when we don't have access to the courts, we're almost out of a job. I mean, we can write opinions just so many times. So, you know, we rely on the courts, and the courts have been doing a very good job, I think, to minimize the kind of disruption. And I want to thank the judge for that. Right. I'm sure she was part of that. And that really kind of brings me to a discussion of the state of claims. There are several states that will post their claims, whether they're litigated or not, whether there's a request for benefits formally filed. They'll post their claims on their Departments of Labor website. Some do, some don't. Some are more transparent in that way. With regard to the state of claims, the last time I spoke to our audience was on May 4th, around there. So it's been about a month. But recently we've had a rash of filings in the states in general, and in the states that I've sampled that actually post their non-litigated claims on their Departments of Labor. Would be California, which at least by mid-April, early May, was up to 1,500 claims filed. Washington State had about 1,000. As we know, that's where all this kind of began, the genesis of it. Ohio had about 500 a couple of weeks ago. With regard to claims in Oklahoma, whether they're litigated or not, I don't think I have not been able to find that number, because a lot of it is depending on what the state requires. And there may be some overlap with OSHA, because their new recordable event recording requirements. As far as litigated claims, Judge Inhofe, this is for you. Do you know of any litigated claims, at least in your jurisdiction?
Well, as far as I know, we have only 2 litigated claims thus far. One of those I believe to be a death case, and the other is a claim where the person did not pass because of the transmission or because of them contracting coronavirus. Those claims, although filed, have, as far as I know, not been active in terms of there being an actual filing for a request for benefits. The filing of the Form 9 or the request for benefits would be what would prompt the case to be assigned to a judge and for it to come up on a pre-hearing conference. I don't believe that that has happened yet because none of the judges thus far know to whom that claim, those 2 claims are going to be assigned. And none of us have had any pre-hearing conferences or other informal conferences, as far as I know, about any coronavirus claims.
I see. Specifically, and this will be developed further in this discussion. Do you see handling coronavirus claims specifically with regard to occupational injury? Do you see those as being particularly demanding with regard to evidentiary standards, et cetera? And we'll talk more about that in a minute. Judge Inhofe.
Well, I do. The evidentiary standard is going to be rigorous. It's going to have to be very well developed in terms of developing causation of the asserted injury or occupational disease. It's going to be a very, very fact-specific determination, I would think, depending upon the means by which the claimant is alleged to have contracted the virus. It's going to be very dependent upon their exposures. Were they a frontline healthcare worker, or was this person employed somewhere else and the exposure to the virus was incidental, like by alleged to have occurred by perhaps a patron or other customer or somebody else who came into the business. It's going to be incredibly fact specific. The other thing I think that's going to be interesting about it and perhaps troublesome from a causation standpoint is because the means of the injury involves a third party, another person by whom the exposure occurred. That's a third party's health information, which is private. And I think that we're going to have some privacy issues which are going to be interesting to work through because while the claimant's health information may become relevant and will become relevant to the litigation because they're asserting contraction of the disease, the person who allegedly gave it to them, they're not a party to the suit. And so we have to be very, very mindful of privacy concerns in that respect.
Understood, and I agree with all of what you said. This one's for this is for Esther. Esther, what kind of evidentiary issues do you see as a claimant's attorney? Well, first of all, we're going to have to. I think we're going to agree. One of the few times that we agree, we're going to have to agree that this is something we've never seen before, the likes of which we've never seen. True?
Absolutely. Absolutely.
Yeah, somebody needs to make sure they record this because we agree. What kind of evidentiary issues or what kind of evidence do you think you're going to have to engage in? to prove a case against me and my client. If I say no, I'm denying this, what's your next step?
Well, it's going to be twofold. First off, what's the client's story, right? What happened to them? Where do they believe the contact occurred? You know, how do they pin? I mean, when they come to me and tell me their story, they're going to need to be able to tell me why they believe it occurred through their job. And so is it more probable than not that their story makes sense? Is it true? And then what is that job? Is it a high risk job like Judge Inhofe indicated, or is it more incidental? Do the employers provide, protective wear? I think that's a factor. I mean, we all know we're supposed to wear it, but do we have it available to us? But their story is just part of the things that we are going to need. Obviously, we're going to need the medical evidence to support it. From the claimant's position, we have the burden of proof. We have to prove, that the injury occurred in the scope of their employment. And of course, that there's an injury, so we'll need medical evidence to support it too. So number one, of course, is there a positive test for COVID-19? That seems simple, but it's still going to be required, I'm sure. And then secondly, what treatment was necessary as a result of that, if we're asking for treatment to be paid for, and then what's their long-term, what we call in workers' comp, do they have permanent disability from it? And if so, how do we prove that? So, it's not just their story, but also medical evidence to support it.
Right. Judge Inhofe, similar question. What kind of medical evidence would you be looking at? And if this is a trade secret, you can tell me. What kind of medical evidence, and I think what you have to say would benefit all of our clients watching this, what kind of medical evidence would be most compelling, at least to assist you in making a determination, whether yay or nay? I'm not going to ask you to take a position, whether or not this COVID is a work-related injury or occupational disease.
Well, like I said, I feel as though these cases are going to be very fact-specific. I think that likewise, the medical evidence is going to have to be very fact-specific. Generally, when I address causation in a denied case, the historical medical record is very important to me. And when I say the historical medical record, I'm talking about perhaps the first time or the pattern of times that the alleged injured worker went to the doctor and what did they tell the doctor about how they were hurt. I don't think that our historical medical record, though, in coronavirus is going to be really as easy to suss out as that. So I think that we're going to be relying more on reports that are procured by the respective sides, the respondent and the claimant. Generally in workers' comp, we're used to seeing an evaluating physician report on behalf of each party. I think we'll see that here as well, but I think we're going to need some more expert help as well from perhaps an epidemiologist, from a pulmonologist to help us address causation. And again, I think that determination is going to have to be very fact specific. In cases that are a little bit different, in the past, I've had medical experts appear in person to testify. And I don't think that's certainly out of the realm of possibility in these instances as well.
So what we're looking at, from what both of you have said, is that our clients and our carriers who are watching us discuss this are going to have to embrace the idea that they're going to have to provide an evaluation to a claimant with, let's say you get to the end of the claim, you're going to have a report from a pulmonologist, epidemiologist, and it would likely be assistive to have it all wrapped up in a package by an evaluative physician, like an occupational medical doctor who we're all familiar with. We all know who specializes in that. Is that what you're saying, Judge?
It is exactly what I'm saying, because, you know, one of these experts, like we're talking about, the pulmonologist report or an epidemiologist report, for one thing, they're not going to be conversant with our evidentiary standards or what is expected from an actual report that is generally utilized at trial. I think that they can give us broad brush strokes about causation, or maybe better than broad brush strokes, but I think that we are still going to have to probably see those expert evaluative reports from physicians that are conversant with our requirements, that are going to help put the bow on the top of that.
Right.
Especially if we get into issues of apportionment, or if there are pre-existing conditions. I think that's going to be even more so important.
And I agree. You're going to need to see a lot of evidence, and there's going to need to be a lot of testimony elicited. I would anticipate, if I was handling a COVID claim, to first wait till the person's better if they're suffering from it, and then depose them and go deep into deposition, following a chain of events up until the point they determined that the problems they were having were related at work, number one, and number two, were related to COVID. That's one of the things that make me know that this is going to be incredibly fact specific, because we haven't seen anything like this in such a large proportion and percentage since the Spanish flu of 1918. And at that point, it's kind of unclear. It gets kind of murky when you start trying to find those cases involving the Spanish flu. And I'm going to get into a limitation and exclusion in a minute with regard to that. But, you know, at that time, most of the state's workers' compensation systems were being developed, 1915, 1917. So everybody was new at everything at that point. And for the longest time in Oklahoma, at least, they didn't even cover things that weren't traumatic injuries. At one point, they weren't even covering people who worked in offices. So this kind of thing is going to call the tune in terms of unpredictability. We're not going to be able to predict a lot of this, but we just have to basically go with our gut, go with stare decisis as to how we've handled stuff in the past. Which brings me to a hot topic that all the defense lawyers like to talk about, including myself, is to what is in everyone's statute is that workers' compensation commissions, workers' compensation acts, courts in various states do not cover what's called ordinary diseases of life. And I wanted to develop that some more. Ordinary diseases of life in many cases are listed on their websites in their statutes. Oklahoma does a little bit, Texas doesn't. Pennsylvania has like 30 conditions. With regard to this, and I'm going to specifically point this at Esther, because it's going to be her job if there's no rebuttable presumption ever passed, which I think has its own problems in the state of Oklahoma. How would you get over the fact that I said, if you and I showed up at court and I said, yeah, we're not covering this, my carrier and my respondent say it's an ordinary disease of life, and here it is in the statutes, and not only in our statutes, but my gosh, it's in every other statute in every other state. How would you get over that? What are you going to say? I mean, I know you're going to tell me some trade secrets, but we won't tell anybody.
Okay. JD, I very respectfully say to you, there is absolutely nothing ordinary about this, you know, very respectfully, of course. And, you know, we've not seen anything shut down the nation like this has, first off. You know, there's no vaccine for it. It's it's trended faster than anything we've seen in our lifetimes. It's not a ordinary, by definition, it's not an ordinary disease of life. So I know that the defense lawyers are going to try to argue that, but I don't think of it as fallen into that category at all. I mean, maybe you can give us some feedback or trade secrets on how you think it would be an ordinary disease of life, like, asbestosis or something like that occurs, over a period of time as well. But I don't think anybody's going to see it as ordinary.
And I think that there's validity in that argument. It has shut down the American economy 3 months. There is no vaccine. It travels faster than we've ever seen any other occupational disease travel. Unlike other occupational disease such as asbestosis, silicosis, black lung, that kind of thing, it takes a while for those to develop, and as such, the statute of limitations are much longer
Right.
for those type of things. In this situation, there won't be any slowing down. You'll know when you have something wrong with you, whether or not it's coronavirus is, a matter of testing. With regard to what I would say as to why it would be an ordinary disease of life, I think I should maybe characterize it on I think I would characterize it more by what it is not. First of all, I would say that all flus are novel. And one of the arguments is that, well, this is called a novel coronavirus. So it's novel, it's unusual, it's different, it's different. And I would say, actually, no, any and all flus are novel. And that means each year the CDC is required to come up with new and different forms of microbiology to attack what is anticipated. So in that year, and some work and some don't. So in that way, it is not as novel because its predecessors are not. And the general flu is not covered. Now, there are certain examples, at least in Oklahoma, and I know in other states as well. This is, well, if you've got a common ordinary disease of life, if you got it at work and you can prove it, then you should be covered. And in all my work over the years, I have seen several ordinary diseases of life be covered, and that's where you're going to have an easier time of it, and one of which is asthma. And believe it or not, asthma is actually the most claimed occupational disease in the United States, or at least was last year. I did have an asthma case one time, and it was a work-related asthma case, and it was determined to be such as this lady worked for a big box hardware store, and she broke a fluorescent light bulb and breathed in the whatever magic dangerous dust is in there. She breathed it in, and she actually contracted an asthma that she didn't have before. So yeah, I see the point that you're making, and that it should be covered, and it doesn't matter, or at least what some people will argue also is it doesn't matter whether it's ordinary or not. She got it at work, and he got it at work, which does bring me to a question that we had heretofore not discussed. When does an injury begin? Does an injury begin at a diagnosis, or does an injury begin at the beginning of negative ill effects felt by the patient? We don't know. In fact, some states don't even define injury. Oklahoma does, but on the other hand, Illinois doesn't. Louisiana mentions accident, but it doesn't mention what an injury truly is. And a compensable injury, at least as far as we've been understood to work with, it's damage or harm to the physical structure of a body or prosthetic devices. That's 85A9A. And I don't want to get too Oklahoma specific, but and there's some other requirements as well. Pre-existing condition is, and has always been included as being part of a limitation and part of an addition. They haven't outright banned pre-existing conditions, and over the years, a person, again, we're talking about apportionment of liability or apportionment of injury. Over the years, that has been argued for, I mean, hundreds of thousands of times, that, well, we shouldn't be, we shouldn't be covering this, or we shouldn't be paying for this because that person had COPD previously. What kind of, should I say, challenges would you have in determining apportionment with regard to a disability in the end of a claim? Judge, I would like to ask you that. What kind of problems would you run into, and what would you rely upon to help you make your decision?
Sure. Well, you know, what you're talking about is when we get to the end of the case and the judge makes a determination as far as how much permanent partial disability somebody has as a result of the injury. So we're going to assume that we've gotten through compensability and that we've established the compensability of this claim wherein somebody alleges that they've contracted coronavirus at work. And they've been through their treatment and now they're seeking their final award from the commission. What I think is going to come into play in terms of making that determination is if we're expecting there to be pulmonary issues that are remaining. Is that what is going to be rated? Problems with breathing or other things? What the respondents are going to be very mindful of is things like, was that person a smoker? Was there ever any problems with COPD, emphysema, any type of breathing issue, asthma? And to the extent that there have been problems, they're going to want a credit, if you will, against the person's condition as they present themselves for their final award. And that, in terms of an evidentiary standpoint, I think that's where your evaluating physician's report is going to be very, very important, because those doctors are very, very conversant with how to apportion, what we need to know in terms of, and what we're looking at in terms of apportionment.
Right, and that I anticipate that as well, and that's where your multiple medical reports are going to come into play. Nobody asks the judiciary to be a doctor, but we, in the law, we use doctors' reports to make projections and things like that. There's testimony, obviously there's testimony that sometimes that decision hinges upon as to whether or not somebody is going to have an apportionment issue. But usually by the time you get to a permanent disability situation, it's not a surprise that somebody had a comorbidity, correct?
Oh, agreed. And I think that your expert, your pulmonologist, your epidemiologist, whomever, they may be able to discuss those issues, those comorbidities, but those evaluating physicians are going to be the ones that are going to be able to actually quantify it. Because as you know, by the time you come to trial for a permanent partial disability issue, if you're arguing apportionment, there's going to have to be a quantification of that.
And I guess we're going to have to leave that up to the doctors, because, I mean, I have no means of determining the quantification. Esther, do you?
I don't, but you know, both sides is going to have their doctors, and then Judge Inhofe and the other judges are going to have to determine which one is more credible and which one makes more sense and which one has the best history. And she fortunately is the one that's going to have to make those determinations. Yeah, but yeah.
True. With regard to proving up a COVID case. It's going to be fact specific. Most people most pundits who are discussing this in the form of workers' compensation, that discussion has led to several states, and I think at present about 22 states have passed legislation, or their governors have issued executive orders that there will be a rebuttable presumption that if somebody comes up with COVID, they got it at work unless they can prove otherwise. Now, this is going to be to Esther. Rebuttable presumptions in workers' compensation are not a new thing, correct?
Correct.
And
Right, no fault.
yeah, rebuttable, and as I recall, having represented several cities in the state of Oklahoma, particularly, there's usually a rebuttable presumption for firemen, right?
So yes, there's certain things that have rebuttable presumption, meaning, if you meet these rules, then it's assumed that you caught that from your job. So, like COVID-19, we all know that healthcare workers on the front line are the ones who's going to be exposed to it on a daily basis. And so the rebuttable presumption would make sense because you have someone who is in contact with it every day. So how about you prove that it's not related then? If you truly believe that it's not related, what evidence do you have that would show that it's not related if they're being exposed to it at their job? Of course, you have those who aren't in contact with it every day or direct contact with it, and I guess those would be harder to determine whether there is a rebuttable presumption that would be appropriate.
Right, and what a rebuttable presumption does, if our viewers don't know, it is a burden shifting tool that is used to really lessen the requirements. It eases up a little bit on the requirements of causation as to how somebody got their injury or how somebody got their occupational disease. It relies on a history of individuals getting that disease in those occupations. Respiratory issues, specifically the firemen. And what has been argued, though, is that passing a rebuttable presumption, in fact, in the issue of COVID, is going to start a slippery slope and is going to start, it's going to facilitate a mass influx of claims being filed for people with the cold. Do you believe that that kind of thing will happen? Can you project that if a rebuttable presumption is in fact passed in your state, or do you not? Esther.
So I think that there are people who wouldn't make a claim otherwise because they don't know, they don't understand what rights they have. I think that if there is a rebuttable presumption, that they would then perhaps submit a claim to their employer would submit it to their insurance carrier, and that would be paid, and maybe there's no litigation that ever results from it. And if you don't have that rebuttable presumption, I think that could lead to more litigation because you're going to have employers, or more likely the insurance carrier as opposed to the employer, who's going to not want to pay that claim. So you're going to spend a lot more on lawyers and doctors to try to prove that it's not related as opposed to just paying for the treatment. So I don't know if I answered your question.
Well, yeah, and there's actually what your position is, and I understand it, is that a rebuttable presumption may be a way to foreclose costs of litigation, because an employer may say, well, okay, maybe consult their workers' comp attorney and say, well, there's a rebuttable presumption that this person breathed in this glass. Did it happen, and are they injured? Well, yeah. Well, they're not going to fight it. Yeah, right. They're not going to fight it. Otherwise, they can handle that in-house. It could be a med-only claim where no lawyers are involved.
Exactly.
And so I can see how that would be a reasonable. It's a reasonable projection. Alisa.
Hello, JD. Yes, I'm going to interrupt you here. We have several questions coming in.
Okay.
This first one I want to start with is specifically for Judge Inhofe. One of our viewers said that they were looking at our Holden Institute slide at the beginning of a presentation, and it said that what the slide had said was that OSHA seems to be lowering the standard for proof of injury for workplace-related COVID-19 infections. And they're asking you, will a cluster of cases in the workplace become a rebuttable presumption that it was acquired at work?
Well, the rebuttable presumption isn't going to come from me or one of the other judges. That's going to have to come in legislatively. So while somebody might seek to admit that in evidence to further shore up a claim that somebody contracted coronavirus at work, it's not going to act as a rebuttable presumption unless that's done elsewhere than in my hearing room.
Okay. And we have another question. It's not for anyone specific, so I'll open it up to the panel. And it is related kind of to what we just talked about, so I think I'll start with this one. It says, if my state has passed a presumption of work-related condition for workers' compensation and COVID-19, will my premium rates increase?
I think I'll take that. Yes, maybe not. That depends on the company who your carrier is. In at least one study that I've reviewed and at least one opinion I've looked at, one of the largest insurance companies who carry work comp in the state of Colorado is a company called Pinnacle. I've never heard of them. I've never dealt with them. But the Pinnacle people have determined that they believe yes. Specifically, if a rebuttable presumption is passed, they're going to raise rates. In fact, if a rebuttable presumption is passed with specific regard to COVID and firemen and first line responders, they anticipate premiums to increase up to 27%. On the other hand, an experience modifier is utilized to determine how much a premium is going to be. Some other insurance companies, and I'm not sure exactly which ones have all decided this, because you don't find out information like that just going down the street. It's just not there. You got to dig around. Have said no, an experience modifier is not going to be affected because this coronavirus business is so unusual that it's anticipated to be temporary. You can't make any long-term projections about the risk valuation of that company based on this. And I like that interpretation because it's very logical.
Right. Okay, so we have time for one more, and everyone, if I didn't get to your question, we will have the answers posted at our website, holdenlitigation.com. I think this one is one I'm going to go with. It just came in, but I think that it would apply to in several circumstances. It says, and this one's open to the panel, of course, it says, with my business temporarily closed due to COVID-19 issues, I am having problems paying my workers' compensation insurance premium. Are there benefits or tolling provisions that can apply to my business based on lack of income?
I'll get that one too. And that's the same as, my answer is going to be the same as the last question. You need to check with you definitely need to check with your carrier. In fact, Oklahoma CompSource Mutual has given reinstatement options for lapse policies. They've lengthened a renewal for a grace period for renewal. They're offering an option to reduce premiums for businesses still paying for non-working employees. They're willing to back off that, and they're willing to offer payment assistance. That's just CompSource Mutual in Oklahoma. However, they're not in the minority. They're not the only ones doing this. So you need to get in touch with your carrier, because they most carriers are not out to ruin you. They're out to help you. And so they need to get in touch with their carrier about that. And you can work something out.
Okay. Well, unfortunately, we are out of time. I want to thank all the panelists for being here today, and just let everyone in the audience know that next Thursday, we will be having another seminar, and it will be over class action lawsuits. And the following week, it will be part 2 of our business interruption series involving COVID-19. So thank you all for being here, and we will see you next week.
Thank you, Alisa, for having me today. Thank you, Judge. Thank you, Esther.
Thank you. Appreciate it.